Okay. Good morning, everyone, and welcome to the Wilson Center. My name is Will Pomeranz. I'm Deputy Director of the Kennan Institute, and I also head up the Kennan Institute's Rule of Law program and have been engaged on today's topic on the role of the private sector in promoting the rule of law in a variety of ways. I had a unique opportunity and privilege to actually practice law in Moscow at the end of the 1990s, which gave me a ringside seat on what it means to actually introduce property rights. And before I worked in Moscow, I actually worked at the National Endowment for Democracy, where I had the privilege of working with CIPE and their excellent work in promoting rule of law and property rights and the private sector throughout the world. I think the conversation of today's event is as important as ever. The rise of populism and nationalism has called into question the rules-based order, and private enterprise and the promotion of private values has been caught in the crossfire of these movements. Therefore, today's event, I think, is particularly timely, not only to discuss the relationship between private enterprise and the rule of law, but on a broader level, how to promote the rules-based order and property rights that so many of us have come to rely upon in pursuing international business and trade. We have an outstanding program today, and it's outlined in great detail in the program. I look forward to hearing from the panelists, and I especially look forward to listening to Tom Firestone, our lunchtime speaker. He is also a specialist in my part of the world, the former Soviet Union, but it seems he's always traveling around the world, and I never get a chance to see him. So I'm looking forward to having him with us today to talk over lunchtime. This is the fourth meeting that we have had with the Rule of Law Collaborative at the University of South Carolina, and they have been excellent partners, and we're so pleased to partner again with them and continue to promote their excellent and innovative work in this area. A special thanks to Joel Samuels, Hamid Khan, Kyle Downey, and the whole collaborative program that has worked its way to Washington, D.C., as well as a special thanks to Madison Brady, who has worked so diligently to get this program underway. We are also here very pleased at the Wilson Center to highlight the work of the Just Track program. Just Track is a cooperative program of the Rule of Law Collaborative, the University of South Carolina, and the Bureau of International Narcotics and Law Enforcement at the U.S. Department of State. It seeks to improve the skills and knowledge of individuals funding, designing, managing, or implementing justice sector programs. It also provides a multitude of stakeholders with the opportunity to share their experiences and lessons regarding justice sector program, and this is exactly what we intend to do today. So with that, I'd like to turn the program over to Hamid.
Good morning, everyone. It is a true pleasure to be here once again at the Wilson Center and to convene together a multitude of stakeholders in probably one of our most important symposia to date, which looks at the engagement between private enterprise and the rule of law. As Will had already mentioned, first and foremost, we are grateful for the continued partnership with the Wilson Center, who has stood steadfast in helping to host our events, and as a result, we are proud to once again convene here with like-minded individuals in this ongoing enterprise we call rule of law. In addition, as mentioned previously, this is part of an ongoing set of deliverables and events as part of the Just Track program, which of course is a cooperative agreement between the State Department and the Rule of Law Collaborative at the University of South Carolina. A couple of housekeeping announcements before we get underway. First and foremost, this session is being recorded, and in addition, we will also have lunch for everyone. That session will not be recorded, and we will try to observe Chatham House rules. As Will had already introduced, Tom is very blunt in his assessment, and he's asked for those participants who engage in the lunchtime session to use it as an off-record discussion about his understanding, particularly in the Russian context today. In addition, we should also note that the conversations and part of the discussion will be tweeted live, and as you can see, the hashtag is on the side walls here. If you'd like to tweet as part of our social media engagement, Twitter has become quite a popular way of looking at things. Today, when we, I'm not going to go any further, but, well, actually I am, because one of the challenges we face when we talk about rule of law, as both my colleague at the State Department likes to remind me, it's all about definitions. And it's very hard to imagine us having this discussion today or the last few months without having competing definitions about what actually means to have the rule of law. What does that adherence actually mean? Because oftentimes we see ourselves almost with eyes glazing over at the various definitions, whether you take the UN definition or you take the various definitions of various bureaus, international actors, or even historical introductions about the rule of law, whether it's the Chinese context, the Islamic world, or here in the West. So when we think about rule of law, we're always searching for that almost elusive definition. Sometimes we say that we know it when we see it. But what I would like to suggest is that the rule of law is really, in many ways, a concert of actors engaged in a larger enterprise. And the hope is that what results is less a cacophony and more of an orchestral piece of music. And one of the important and vital elements to this concert of actors is the engagement of actors within private enterprise, corporations, those who engage in the on-the-ground work that sometimes we don't see and that governments often acknowledge. But today, we are going to spend time looking at how corporations, how their engagements have affected the rule of law in local contexts, how they have been regulated by international standards, and how their moves towards self-regulation have set the example for how other corporate actors have engaged. And of course, this is an evolving process. Like much of what we have learned about the rule of law, there is no one clear answer to every definitional problem. But inasmuch as we have looked at this idea of the rule of law as a concert, inasmuch as we have tried to listen to the music, in many ways today we add a specific note that has often not been heard. And that is to look at and examine closely with a very clear tune as to what we can learn from private actors in their engagements as well as the enterprise writ large. So it is with great pleasure that I turn the session over to our first panel. But I, again, would like to extend my gratitude to the Wilson Center, to the Rolk staff who have been steadfast in accomplishing, and of course to our INL partners who helped make this happen. So with that, I'd like to turn over the first panel. Thank you.
Great, thanks.
So good morning. First, I want to make sure everyone can hear me and apologize that I have a bit of a cold. May make it a little bit more difficult on the audience. But people in the back, if you can hear me, raise your hand so that I know you're okay. Good. First, I want to start by thanking the Wilson Center and the Rule of Law Collaborative for putting this event together, and Hamid for all of your good work organizing all of the moving pieces. I think we have a really interesting agenda, a great group of panels and participants. So I hope that you all are able to really take advantage of this event and all of the knowledge and experience that's going to be collected here today. As the title for this first session, Surveying the Global Legal Landscape, alludes to, this beginning session is really intended to provide a kind of broad overview of the current landscape facing companies operating around the world. That is a fairly Herculean task because this includes addressing substantively the full scope of issues that companies have to address that fall within the umbrella of rule of law, including environmental issues and challenges, social issues, including human rights issues, and governance issues, including corruption, transparency. In addition, on sort of another axis, legally, we are dealing with a confluence of different legal regimes, international law, local law, hard law, soft law, voluntary, mandatory, and regulatory standards, all of which are sometimes reinforcing, sometimes in tension. And so that dimension is also quite complex. And then lastly, the third dimension that I hope we can begin to sort of map out and explore and set a framework for you all in this panel that will be helpful as you go through the rest of the day is organizationally. And there are a number of influential and important organizations in this space, some of which are represented on this panel, others will be represented later on. And they take different forms. So you have industry associations that work usually with companies in a common sector, but sometimes based on geography, companies who are working in a similar region but may be working on different issues or selling different products or services. You have multi-stakeholder initiatives, which is a newer, but certainly a growing trend for addressing some of these complex rule of law and governance issues where companies together with civil society and governments, often sometimes academics, sometimes investors, will work to set us a standard that is seen as being above and beyond what may be applied through local law in some of these low rule of law environments. But those are voluntary commitments and they rely on a certain degree of self-policing. And then there are, of course, multilateral organizations where governments get together to work to set common standards and approaches, oftentimes, again, in collaboration with other stakeholders. So we're going to hope to sort of explore those different ways of thinking about this landscape. I hope that we provide more clarity and insight than confusion. There are a lot of acronyms. There are a lot of different standards and codes, and we'll try and bring some clarity to all of that. It is a daunting task, but fortunately we have a fantastic panel, very well positioned to cover that broad and challenging waterfront. So I'm gonna start by giving just very quick introductions to the three panelists, and then offer some questions to sort of tease out the conversation. We'll hope to get through the questions, relatively quickly, so that we leave as much time as possible for question and answers, so that you all can chime in and be part of the conversation. So very quickly, I guess starting on my right. Christina Koulias is the Senior Manager for Governance and Legal at the United Nations Global Compact, which is the world's largest corporate sustainability initiative. And she leads the governance unit there, which includes works on issues like anti-corruption, humanitarian needs, peace, and rule of law. Next, further to my right, is Malika Yetkin, who works with me at the State Department and is a good friend and colleague. She is the Senior Advisor for Corporate Responsibility in the Economic Bureau of the State Department. She also serves as the United States National Contact Point for the OECD guidelines for multinational corporations, which is something that she'll talk a bit more about. And finally, at the end of the long table here is Frank Brown, who is the Value Chain Anti-Corruption Program Leader at the Center for International and Private Enterprise, CIPE, which is a nonprofit affiliate of the U.S. Chamber of Commerce. Frank has a long and very distinguished career, first as a journalist and more recently now at CIPE, working all over the world in areas of low rule of law and challenged rule of law governance, and works a lot in his current capacity in emerging markets, including on issues related to corruption. So to get us started, I thought we would talk a little bit about perhaps the the first and one of the most important and most overarching frameworks for addressing the broad range of issues that companies operating globally have to deal with in the rule of law, under the rule of law umbrella, and that is the OECD guidelines for multinational enterprises. So Malika, can you tell us a little bit about the guidelines, how they were developed, how they have expanded, and how they are applied today?
Absolutely. Thanks so much, Jason, for agreeing to moderate our panel. Thanks to Hamid Khan, to the Wilson Center, and to Just Track for hosting this great event. To answer your question, the OECD guidelines, as the government sees, are one of the two key documents that we point companies to encourage high standards of corporate responsibility best practices. The OECD guidelines were adopted in 1976 by the OECD member states, the Organization for Economic Cooperation and Development based in Paris. And those guidelines have several chapters on a lot of issues that directly relate to rule of law: transparency, human rights, labor rights, supply chain management, anti-bribery and anti-corruption, competition, science and technology, you name it, reporting. And they're really a set of guidelines to businesses on how to operate responsibly. And governments wrote them in partnership with business. And in 2011, those guidelines were updated, as they have been multiple times, and they added a chapter on human rights and on supply chain management. And we've seen many people in the audience, and I know us up here on the panel, over the past, especially 5 years, the area of human rights, supply chain, and value chain management has really expanded. And the guidelines needed to account for that. And one of the second important documents that the OECD guidelines calls on is the UN Guiding Principles on Business and Human Rights. So the State Department, the US government sees those two, the OECD guidelines and the UN Guiding Principles on Business and Human Rights, as the guidelines to companies on how to operate.
Thanks, Malika. And yeah, so the OECD guidelines, I think one of the important takeaways is its breadth. As Malika indicated, it has chapters on just about every issue that companies face, in particular in areas where rule of law may be a challenge. And I think that's important that we have some of these documents and standards that really help to tie all these things together. Another more recent multilateral work product that tries to address a broad range of issues, not only those dealing with rule of law, but also those really affecting the issue of development, is the UN Sustainable Development Goals, which were adopted just a couple of years ago and meant to guide the work of governments together with all the other important actors in the international space, including multilateral organizations, private companies, civil society, in achieving some core development indicators to raise the living standards of people around the world. And Christina, I know that the Global Compact has been very involved with the Sustainable Development Goals and their development and promulgation, and in particular with Goal 16, which is the goal among the set of Sustainable Development Goals that really focuses on issues related to governance. So I was wondering if you could tell us a little bit about your work on Goal 16 and also how that ties into the broader Sustainable Development Goal project and what people should know as they seek to understand this landscape and how the Sustainable Development Goals fit in.
Absolutely. Thank you. Thank you for that. And again, echoing Malika's lovely comments about just feeling very privileged to be here today to speak to you all, and thank you for inviting me to speak. It's interesting, just taking a step back is understanding the nexus between the OECD guidelines and also what the UN Global Compact does. And I think it goes without saying that they're quite complementary. And, so the UN Global Compact has its mandate by the UN General Assembly, so that was, of course, endorsed by 193 states. And part of our work has really been to advance corporate sustainability globally. And as Jason mentioned, we are the largest corporate sustainability initiative around the world. And so what what that does for us is puts us in a very privileged position to be able to engage with the private sector, those that participate with us. So we have over 12,000 companies and small to medium enterprises across all regions around the world who engage with us. And what we did as part of the Sustainable Development Goals is engage with them. We had this convening power where we had a sort of tapped into our local networks. So we have over 85 active local networks around the world. And we managed to engage with them around what they thought were important issues in the development of the Sustainable Development Goals. And, and it was consistent. All of the goals, the 17 goals, and they are rather ambitious to be sure, but they are comprehensive. And so what was great about that is bringing the private sector on that journey together, and to also have their own way of endorsing those goals has been really critical. With respect to Goal 16, I think it's pretty common knowledge that Goal 16 was probably one of the most challenging goals of the SDGs. And I can't tell you how excited we were to see that it made the final cut, particularly any reference to rule of law, which I thought was, quite an interesting journey. With our work, what was being fascinating and I think also very humbling but also reinforcing is the voice of the private sector in emphasising the importance of rule of law. And I have a couple of colleagues here. I can see Teresa here from LexisNexis. But we've worked on a major project around creating a framework for business for the rule of law. And so that was actually the brainchild of a private sector organisation, being LexisNexis. But we managed to also garner support from major companies, and firms, including Baker McKenzie, Linklaters rather, other law firms, but also Unilever, Nestle, Barrick Gold, I think Jonathan will be speaking later, Vale and others, who really do see the power of having just strong institutions and legal frameworks in order for them to have a level playing field for them to be able to operate. So that has really been, I think, one of the most important pieces of work that we've done. And in terms of the connection with the other goals, arguably, without sounding biased, because that's my focus on Goal 16, but it's foundational. It's, without the rule of law, without those strong institutions, without the absence of corruption and other such issues, without peace, you can't advance those other goals. And so we absolutely see them as being entirely critical.
Wonderful. So we'll come back, I think, more to some of the interplay between these different sets of standards and overarching frameworks. Before we do, Frank, I wanted to ask you to talk a little bit about the interplay between corruption, which is something I know you've worked a lot on, and human rights, which is the focus of the UN Guiding Principles on Human Rights, which is endorsed also in the OECD guidelines. There's been research showing that corruption, in addition to being a drag on the economy in and of itself, has a negative impact on human rights. And I was hoping you could talk a little bit about how business can address that particular issue.
That's a tough question, but so I'll explain a little bit about our work at the Center for International Private Enterprise and how gradually we've been expanding it in that direction so that it does encompass elements of human rights. So much of our anti-corruption work is driven by the existence of very powerful laws like the Foreign Corrupt Practices Act, the UK Bribery Act. Evidence of that power is visible in just the sheer dollar value of the penalties. In 2016, over $2 billion in penalties arising from FCPA prosecutions. So these are laws that that companies pay tremendous attention to because they involve substantial risk, both reputational and in terms of actual business. As we've worked in this sphere in emerging markets, we've seen a natural sort of progression into other areas, including environment and labor. And again, we look for the legal underpinning to those two issues. So in the case of environmental issues, you would look at the Lacey Act, and there was an enforcement action by the DOJ, I think about 18 months ago, against lumber liquidators for about $11 million regarding illegally harvested timber in Siberia. So that sent a very clear signal to businesses working in that area that they had a new area of risk they needed to manage. We also look at labor legislation and changes to it, and the degree to which U.S. Companies or companies that do business using U.S. instruments like stock exchanges, ADRs, that sort of thing, are subject to labor laws that have been evolving. And we looked at the interconnectivity of all three of these issues, because corruption really is the glue that binds them together. So if you're using forced labor to harvest illegally obtained timber in eastern Siberia, moving it into China, turning it into furniture, or moving it into Vietnam, turning it into furniture, and then selling it in the US, you've got this sort of perfect storm of risk from our point of view. It's a nightmare from a corporation's point of view, that encompasses a whole multitude of issues and begins to speak to human rights issues in a way that doesn't appeal to the moral dimension of human rights, but cast this in terms of risk management. And that's not to say we don't talk about the moral dimension, but we find in emerging markets we get the most traction when we go to a mid-sized company and say, if you want to join a value chain, if you want to do more business, be more attractive than your competitor, you need to address these issues that your buyer based in the West is going to be paying attention to. And I talk mostly about US laws, but there are counterparts in the EU, in Canada, that have just as much sway. And this is a development in the past 2 or 3 years, and it's quite encouraging.
That's very interesting. And so I think we'll talk a bit more about situations where you have hard law that really provides clear guidance to companies as to sort of what red lines they have to respect, and areas where perhaps laws are not on the books or laws exist, but the capacity to enforce them is quite limited. And of course, you have the challenging issue of extra-jurisdictional enforcement of some of these laws, which requires a lot of resources and a lot of political will. But turning back a little bit before we get into some of those sort of more detailed conversations, Malika, I wanted to ask you to talk about, again, sort of thinking about the overarching framework here. We hear a lot about a couple of terms that I think are similar but have some important distinctions, and I was hoping you could kind of tease them apart a bit. One is the idea of corporate social responsibility, CSR, which has been around for some time and I think means sometimes different things to different people. And the other is responsible business conduct, which is something that comes from the OECD guidelines and is something that we've used in our U.S. National Action Plan, which we'll talk about in a little bit. Can you tease those apart? And of course, there's a third term, which is business and human rights, which is the three-letter acronym BHR that comes from the UN Guiding Principles, and we can talk about that too. But in particular, I wanted to ask you to explain how you see the difference between CSR and RBC.
Absolutely, and Hamid alluded to this morning. Definitions are important, and so how the terminology I use, how it benefits or builds on the other panelists, and I think Frank's remarks were actually a great segue. So the U.S. government produced a national action plan on responsible business conduct, which is our comprehensive policy on how we set the environment for responsible business for U.S. companies to operate, what we expect of U.S. companies, and identifies some gaps and new commitments on how we can help support that effort. And we specifically designed it to talk about responsible business conduct, not corporate social responsibility. And I'm going to describe why, but first we're going to have a little audience participation. Just yell out first thing that comes to your head. What do people think of when they hear corporate social responsibility? Charity, philanthropy. No one else. Come on, guys. Shareholder relations. So everyone has a little bit of a different take on what corporate social responsibility is. And so as the U.S. government, during this National Action Plan process, we decided to not use the term corporate social responsibility because of all the different reactions that some people bring and think of when they think of corporate social responsibility. Greenwashing, philanthropy, charity, policies and procedures that a company is doing. And we stayed away from that into responsible business conduct, really looking at the do no harm principle, And not just making the moral argument, as Frank was saying, for doing the right thing, but rather responsible business conduct is about the way a company makes its money. What are the policies and procedures that that company has in place that help their bottom line and contribute to the rule of law and human rights and operating in a transparent way, et cetera, and that benefits the company by doing it. And let me give you one example. So GE has operations in Saudi Arabia, and they've decided to exclusively hire women for that particular operation. And they've hired thousands of women. Now, generally, that might not be particularly significant, but given that it's Saudi Arabia, it is. They're making a business decision, a policy decision, to advance their business interests that have actually led to great profit in the country and encouraged a signal to the government and within their own business. McDonald's has done the same thing in Germany. They've specifically trained and hired refugee workers. They're dealing with a public policy issue, but it's in line with their core business model and still contributing to their bottom line. That's the argument we've found to be way more effective with businesses than just the moral obligation to do something. Now, it's not either or, you can have both in many of these areas, but the US government has tried to work with companies on what that benefit could look like, and the term we use is responsible business conduct.
Right. So when we think about looking, companies looking at, how they do business and, trying not to be distracted by what they may be doing on the side, which can be wonderful and important, but isn't really the focus that we're talking about here today. We talked about the issue of compliance, which is really a reactive posture where companies have to understand the legal landscape and try and ensure that they are complying with all of the various laws that may apply to their conduct. And then we talked a bit about the proactive steps that companies can take, and Malika gave some good examples. On both sides of that ledger, I think one of the really key actors within the corporation, or sets of actors, are the lawyers, as of course are the lawyers who serve as outside counsel.
Mm-hmm.
I know, Christina, that you all have done work with lawyers through the Global Compact, and I was wondering if you could tell us a little bit about how you see the role of lawyers, both inside companies, in-house counsel, as well as those who serve as outside counsel, in ensuring that companies understand both the reactive compliance-related concerns that Frank talked about a bit, as well as the proactive opportunities and expectations that may exist in different societies and countries, even if the law doesn't dictate certain conduct.
Absolutely. So just, I think, reinforcing what both Frank and Malika have mentioned as well about the idea of what we call now corporate sustainability. We've got lots of words and definitions today. But, we really try and focus on what is, the business's long-term value in financial, social, environmental and governance or ethical terms. And, just reinforcing that narrative around, what is, it's about doing no harm, so picking up on that, and also making a positive contribution. And I think, having, and as you say, it's not one or the other, but we absolutely do say that the minimum baseline is do no harm. To the point of some of the participants that yelled out that, corporate social responsibility is seen as philanthropy, and it has been, quite honestly. And I think for us, what we're trying to do is try and get some consensus and I think it's such a great way to be defining it as responsible business conduct, and certainly language that we use, is that that companies remember at the minimum baseline is to do no harm, and then to then also explore whether it's concurrently or as a stepped approach to making a positive contribution. Now, the way that lawyers come in, typically what's happened is it's always been at the back end when a catastrophe happens. So a lawyer, something happens, there's, it's on the front pages of every website or, of paper, and a lawyer will come in and they'll get told to be given their advice, and then they'll sort of get wheeled back out again. Or they're often being perceived as the Department of No. So no, you can't put that in a policy statement. No, you can't put that in a report. But what's been interesting over the last few years is we've seen wonderful discussions, in corporate counsel publications, but also in academia, but also just generally as we're having conversations with in-house counsel, that they're starting to see that they have a much more impactful role in advancing corporate sustainability and, of course, responsible business conduct. So another piece of work that we did is we developed a guide for General Counsel on corporate sustainability, and Linklaters supported our efforts in that endeavour. And what we did is we undertook some interviews with, I think, circa 40 General Counsel, and asked them, took 90 minutes of their time, which is obviously very challenging, and they took that time out to have a meaningful conversation about what they thought their role was. And some General Counsel were very enlightened, and they said, absolutely, we should be engaged in corporate sustainability or responsible business conduct, however you want to define it. To be able to be there early and engage with business, whether it's to do a risk assessment or whether it's just to see what, innovative idea and what are some of the complexities around that. Being able to engage in those discussions early will help to not only mitigate risk but also find sustainable solutions and opportunities for a business. And that has been quite the compelling narrative that we've seen. And interestingly, going back to Business for the Rule of Law, a lot of the time, their challenge was that, when they're advising their client, whether it is an in-house counsel in a company or whether it's an in-house sitting in and speaking to C-suite, is the rule of law. That came up a lot for them in terms of making sure, especially when they're working in different markets, to be able to understand that they have the safety of the rule of law to anchor their work in. And interestingly, going back to the SDGs, what I think is really important to emphasise is it's not that thing that's weak in a country over there. What's powerful about the Sustainable Development Goals, it's about every member state, all 193 member states, saying that they will commit to cleaning up their own backyard and also supporting others in doing so where they don't have the resources to do so. But what's interesting, I guess, in the role of business is, and in particular the role of in-house counsel, is understanding the legal landscape and just how much it has evolved. Frank's point, particularly around anti-corruption legislation, has sort of just absolutely flourished in the last few years. I also think the great work of under the Foreign Corrupt Practices Act and the enforcement by DOJ, I think has had an impact on that. And also sort of now we're starting to see that cross-jurisdictional collaboration and alignment. Now just recently in my own country in Australia, we're starting to see that they're making more amendments that are going to align with the UK Bribery Act. So this all is very encouraging, and I think it goes without saying that we have to have lawyers at the table in order for them to engage with the corporate social responsibility specialists, but also at the C-suite level and those that are making those business decisions, not wanting to dilute the wonderful role that corporate sustainability specialists have played within companies for many years. But I think it really is about trying to elevate it now to another level of discourse within companies so that we are thinking about it seriously and really sort of looking at how corporate sustainability is also just a synonym for responsible business conduct.
Yeah, very interesting. I mean, it's sort of reviving the idea of lawyers as counselors and not just as advocates or
Absolutely.
as compliance lawyers. So, Frank, turning to you, you've had quite a bit of experience working in some emerging markets where rule of law has been a challenge for companies. I'm curious, thinking tactically about how to get businesses to address these risks. There are a variety of different approaches that governments and other stakeholders have taken, and you can generally divide them into sort of two categories: those that are seen as incentives or carrots, and those that are seen more as punitive measures or sticks. In your experience, what is the right approach? Does it depend on the environment? Does it depend on the sector or the company? Elaborate a little bit based on your experience on the carrot versus stick tactical decision.
So I think my sort of revelatory moment came a couple years ago in Pakistan with a couple colleagues, I think, who are here, Mark and Jenny from SIPE, when we started talking about the FCPA and these terrible fines that were coming out and the horrible reputational risk to, for example, textile producers in Pakistan or the folks who manufacture pharmaceuticals. They didn't really care at all about that. And what they wanted to hear about was what sort of opportunities they could realize business-wise if they put in place a state-of-the-art anti-corruption compliance program. And in addition to that, because they'd just been granted GSP plus status by the EU, they were very interested in what sort of labor offerings we had. How could we train their HR people to make sure that labor standards, EU labor standards, were being upheld, and the same held true for environmental standards as well. And that for us was a very interesting moment. And when you look at Pakistan, you know, there was a case from 2 or 3 years ago involving Smith & Wesson, a fairly minor FCPA case, I think, that resulted in a $10 million fine against Smith & Wesson, that a third party had bribed police departments in Pakistan to purchase their weapons. But that was about the extent of Pakistan getting sort of caught up in the FCPA. So it was perfectly understandable why the stick approach didn't work. The other thing is that in a lot of these places, US laws, UK laws, the last thing in the world they want to hear is how some NGO is peddling US or UK or European standards, right? They are very proud of their own set of laws and constitution and standards and development. So in a place like Kazakhstan, for example, we talk about the OECD principles when we talk about anti-corruption, because that's a neutral sort of set of standards that's perfectly consistent with FCPA and is a wonderful foundation upon which to build, and has built into it all sorts of mechanisms to issue report cards. So overall, that's what we've found.
That's it's very interesting to hear those sort of on the ground experiences and how people have reacted to different approaches. So we've got about 5 minutes till we're at 10 o'clock, and then I think we have 15 minutes until the panel is over. I want to make sure we reserve that time for questions. So very quickly, I want to go kind of back around the horn here and ask you all to talk a little bit, give you the opportunity really, which I neglected to do at the outset, to talk a little bit about the work and the institutions that you work for. So Malika, in your case, maybe a little bit more about the National Action Plan and or the National Contact Point role that you have.
Fantastic. So as Frank was saying, building on that, how we communicate with governments and what our expectations are and the laws we create as governments and how we encourage certain implementation is extremely useful when you're talking about corporate sustainability or responsible business conduct or what have you. And so the U.S. government underwent a process that amounted to the National Action Plan on Responsible Business Conduct, which is available on our website, state.gov/RBC, if you want to take a quick look. And the idea behind producing that was that we were looking to explain what we do to help set the conditions for responsible business conduct, what some of those laws look like, FCPA and others that we have on the books, and what are ways that we encourage corporate implementation? What standards do we espouse? Right now, the OECD guidelines and the UN guiding principles, and we, of course, mentioned the Sustainable Development Goals. And then what are some gaps that we have where we might be able to actually strengthen those pieces? And where are some new commitments that we've done? So all of that is encompassed in this national plan, and it's the first comprehensive plan we've written in that way. We had a dozen agencies contribute to it. We all were singing from the same song sheet, trying to figure out how do we partner with business? How do we work with business? What does that look like regulatory-wise? What does that look like just in terms of collaboration? And how does that help tell the story of U.S. businesses operating abroad? And how can we support those good efforts? How can our embassies actually support that work and our policies and our human rights reports and all these different tools that the U.S. government offers? And so that was the impetus and the reason we created it. And certainly now, as we are going on a roadshow talking about the National Action Plan, it increases our partnership and collaboration for us as a resource to business, but also encouraging those higher standards of sustainable business practices. And just really quick on the National Contact Point work. So through the OECD guidelines, there is a requirement, because they are non-binding and because they are simply just guidelines that companies can implement or not, built into that is a non-judicial opportunity for remedy. So if any entity wants to bring about a complaint against a U.S. company or any OECD headquartered company, alleging that they could have violated these guidelines, they can do so. And each OECD government has a national contact point. As Jason said, I serve in that position for the United States. And they bring about a complaint with the idea of going to mediation to resolve the issues. It is not judicial, it's not binding, it's voluntary. It is really just an opportunity for entities that may not agree on certain issues that are happening on the ground, whether it's on transparency, anti-bribery, human rights. They can go into a neutrally funded mediation space and resolve their issues. And it's really a wonderful opportunity for them to be able to do so. And we've continued to get additional cases. We've had about 20 since 2012. 3 in the past year have gone to mediation, so it's something that's being used for really strong access to remedy.
And so, Christina, over to you to kind of backfill us in a little bit about, you mentioned some of the specific projects that the Global Compact has done, but tell us a little bit more broadly sort of the role of the Global Compact in this broader kind of landscape, and how the Global Compact's work relates to some of these standards like the UN Guiding Principles on Business.
Absolutely, sure. And it's quite a nice segue actually from Malika as well about the national contact points. So as I touched upon earlier, so the United Nations Global Compact is the world's largest corporate sustainability special initiative. We have over 12,000 participants. We call them that deliberately and not members because we are a neutral body, and so we are a part of the United Nations. And so what we do is we invite CEOs of companies or the highest level of an organisation to write a letter to the Secretary General stating that they commit to advancing the 10 principles of the Global Compact. And they are anchored around human rights and labour, environment and anti-corruption. So very much the topics that we discussed today. Upon signing that letter and submitting it to the Secretary General, they then join the Global Compact. And then upon the anniversary of that letter, they are required to submit a communication on progress, stating how they are moving towards realising the 10 principles. And so with that, of course, we like to consider ourselves a guide dog, not a guard dog. So it is, to Frank's point earlier, there is something to be said about trying to be collaborative rather than combative. To be sure, there is a role for both of those functions, and to be sure, it goes without saying that as part of our mandate is to try and get multilateral stakeholder engagement. So where the voice of business is important and the voice of governments is important, we also think that NGOs and civil society are absolutely critical as part of this process. And as Frank and I were actually talking about earlier, you know, there is this concern around the shrinking civic space and how there are, you know, concerns around human rights and environmental defenders and their ability to be able to lend their voices to very important issues. What we try to espouse at the Global Compact is having this safe space where, as part of our 85 local networks, around the world, that businesses, governments, NGOs can come together to talk about important issues. And we've seen that work really well in the anti-corruption space. We've actually, interestingly, as part of the Siemens Integrity Initiative, which is, of course, an agreement that was reached with the World Bank after their own scandal, we've been able to use some of those funds to be able to focus on countries such as Japan, Brazil, Nigeria, and Kenya, and others, and India actually, to look at how businesses can work collaboratively with other actors on addressing issues such as corruption. That's just a little slice of what we do.
Excellent. Very important work indeed. And last, back to you, Frank, to talk a bit more about CIPE's work. And as I understand it, CIPE, you know, as part of its mission, really works in these emerging markets with weak democratic indicators. So I was hoping you could tell us a little bit more about how these international principles and frameworks that we've talked about apply to the work that you guys have done and are doing.
So the most concrete example of that would be a booklet that was put out by my colleague who's here, Anna Kampanek, that really distills a lot of these principles into one easy to understand booklet aimed at mid-sized companies and lay people. And it's been translated into, I think, 4 or 5 languages at this point. But one sort of concrete example of how that booklet is being used is in Russia, where Russia a few years ago was on track to join the OECD, was put in place a series of laws that had began to align itself with the OECD Anti-Bribery Convention, was taking real concrete steps and opened up a whole discussion about anti-corruption that was fascinating to witness. And so you had the Council of Europe bringing in experts from all over the world to talk about anti-corruption issues in a very, very plain and honest way. And they could only talk about it to a certain point, and then they had to cease the discussion because it would lead to unpleasant, for the participants, consequences. But all the same, you could see this young generation at this 2-day conference at the Higher School of Economics in Moscow, which trains the elite. These folks just soaking up everything and seeing the connection between anti-corruption and governance of a country. And you could see a generation from now how the seeds were being planted for significant change. And that's really, I think, a big part of SIPE's role, is to convene players and present information in a fairly neutral way, in a very practical, business-oriented way, and move forward, and be opportunistic as well, because we're fortunate to have much of our funding come from the National Endowment for Democracy. It gives us a tremendous amount of nimbleness. So in a country like Indonesia, where we see that we can work with the World Resources Institute on illegal timber, and we can work with Verite, or Solidarity Center, on labor issues, we can quickly roll out a program that puts something we're calling integrated compliance together. So it's anti-corruption compliance, labor, and environment all together, one big package, and presenting it to companies in Indonesia. So that's really SIPE's role, I think, is to be quick on our feet, to be neutral, and to speak to that basic human desire to improve yourself materially. That's pretty much it.
Excellent. Important work. So we've heard a lot about a variety of different efforts that are underway, and a variety of different standards and frameworks that are relevant for companies that are operating internationally, especially in areas where rule of law is a challenge. And we've heard a lot, I think, reinforcing the underlying point that the private sector not only has sort of these reactive legal obligations, and that isn't necessarily new, although the number and types of laws that may apply to them is continued to expand over the years. But more importantly, that there is a desire, and actually really an expectation on the part of global stakeholders, that the private sector also play this kind of proactive role. The SDGs are the most recent and one of the most important examples of this, but Goal 17 actually talks about the role of non-state actors in contributing to the realization of all of the 16 goals that are the really substantive goals. And I think that's a really important recognition, a really important moment to sort of take note of, that all of the countries in the UN, which is essentially all of the countries in the world, have acknowledged the importance of the role of the private sector and sort of said, we can't do this alone. So there is this real desire for the private sector to step up. We've also talked about the fact, though, that that is not something that should be done sort of or seen in isolation, or in sort of as a way to compensate for companies not complying with their sort of the minimum expectations. And those expectations have continued to rise. And they're not just expectations related to legal issues like corruption, but also broader social challenges that may be present in the places where they work. And so it is a complicated picture, but I think some of the, hopefully, the hopeful notes here are that there is a lot of coordination. There is an attempt to make sure that all of these different standards are complementary. There's a lot of collaboration between the various institutions and organizations working in this space. So with that, I want to turn it over to you, the audience, for questions for the panel, so that we can get to the root of some of the concerns and questions you may have. They can be questions about issues that we talked about, or other issues that you all are thinking about and want to hear from this panel. Yes, right here.
Hi, I'm Terry from LexisNexis. Thank you all. This was an amazing panel. My question is about time. So when we think about rule of law, we can think of it two ways: either projects that are going to be completed within a short time frame or almost generational. And so as you were going through your explanations, could you tell me how you see time playing into what you're working on?
Very interesting question. Anybody want to kick us off on that?
Yeah. Oh, sure. So I think a big role. You know, I think that it's that whole about planting the seed and waiting for it to grow. I mean, we've seen, you know, things like laws being made and social attitudes changing take time. And it's, you know, it's funny because, and again, it was a conversation that Frank and I had earlier, you know, I feel like now is such an interesting time to be alive, particularly around the rule of law. You know, not just in this country, but globally, you know, and as mentioned in Will's opening remarks, is this idea. I think, you know, you watch the news and I think you hear rule of law mentioned on a daily basis. And I think that it's something that we should always be mindful of, particularly as the professionals that we have here in this room and those that, you know, that we engage with externally. And so it's both. It's about making sure that, you know, we have this big elephant that is the rule of law, that's the end game, but it's about having these incremental important projects that Frank and Malika have mentioned as well. We have to have these little projects that help us to advance the rule of law, but ultimately, in order for us to drive substantive change, is that reinforcing narrative around the philosophy of rule of law, the importance of rule of law, whether it's what I call procedural rule of law, which is the institutions and the structures that we have in place, but also the substantive rule of law about having anti-discrimination laws or laws against corruption or that protect our environment. So I think it's certainly important to have a short-term and a long-term game.
I agree with that, and also it's helpful to get the success stories of what's working. As a government, we speak to a lot of other governments and businesses and key stakeholders, but part of that is being able to tell the effective story of how this is changing things on the ground. What specifically does that mean? How long does it take after you create a law? We're not looking for the quick fix. Nothing is going to be fixed overnight, but this long haul is certainly what it's about. And furthermore, I say all the time, I wish we could fast forward 10 or 15 years and see how one would hope the fruits of our labor now are really actually showing. That's a fairly short amount of time when you're talking about the type of change we're trying to affect. But it's possible now with how quickly things are changing. So I agree, it's both.
Yeah, Terry, it's a fascinating question because it's something we think about an awful lot. Because we often try to anticipate where change is likely to occur. And so there are various sort of academics who work in this area who have theories about 20 and 30 year cycles involving the oligarchs or, you know, elites acquiring wealth and then their ability or inability to pass that wealth on to their offspring. Theories regarding international financial flows and the degree to which that has speeded up those cycles because you need to hide your money somewhere, you need to launder your money somewhere. And as these frameworks come into place that control those flows and monitor those flows, it's harder and harder to do. So perhaps the cycles are getting smaller or shorter in duration. But I think that regardless of the answer to the question of time, I think one of the most important things you can do is create a narrative so that when that cycle reaches a critical point, the voters, the folks who are going to take to the street, are informed enough to make a good decision about what sort of best practices they want to put in place and what sort of bodies can address the issues that they've been suffering from for the previous generation. But it's a wonderful question, and it's one reason it makes this kind of work so interesting, because it's very hard to predict who's going to react how and when.
Yeah. Well, one thing just to add to all of that I think is worth noting is that, you know, there are a variety of different areas where corporate expectations have evolved from sort of voluntary to more mandatory approaches. And you've seen that with corruption issues, and you've seen that also in the environmental realm. I think you're starting to see that with regard to some of the social expectations of the private sector. And so there is perhaps some value in looking at those distinct but related areas of corporate practice and corporate expectation to try and understand some of the trends. Perhaps the timescales are not going to be the same, and Obviously, each of those areas is going to go through its own unique sort of process of development. But I think there is a trend that you see towards these voluntary arrangements preceding, sometimes, not always, and it's not always necessarily a good thing or a necessary thing, but in general, leading up to more global and uniform approaches that are baked into enforceable regulatory or legal regimes. So we see a bunch of hands. So let me take two, and then we'll come back to that instead, then I'll take these two. So right here.
Hi, Kate Howard, Sadewald Consulting. I would like to hear the panelists speak to how much short-term, medium-term, and long-term profitability comes into play when you're engaging with the private sector.
Thank you. And then the gentleman here.
Hi, I'm Jim Michael. I'm an independent consultant. I wonder if the panelists might talk a little bit about the application of their work to local business as opposed to multinational business concerns, and especially in developing countries. Frank mentioned Pakistan as one example, but it seems to me if you're talking about changing social values and attitudes, part of the effort that goes into this dialogue is engaging local businesses in the developing countries who are, after all, going to be principal actors in the implementation of the Sustainable Development Goals.
Yeah, great question.
Good questions. Okay, so the two questions, just a short recap. The ways in which short-term, medium-term, and longer-term profitability affect corporate understanding and decision-making in the rule of law space, and then the question from Jim about how your work, all of the work that you do, applies to local businesses, how we can do more to understand how to influence local businesses. So who wants to go first?
I went last time. I don't. So I'll let you guys. I'll defer. Yeah.
I can tackle the profitability question. So I'll give you a practical example of our work, a way that business has in Thailand got together to, in a highly sort of volatile political and business environment racked by corruption, business got together in order to bring a degree of stability that would enable them to be more profitable. And this is a kind of a fantastic example that hasn't been replicated elsewhere in the world, but you had businesses in the face of sustained corruption and the government's inability to deal with it, you had businesses get together and put down a set of basic guidelines and principles and commitments they were going to make to adhering to anti-corruption standards and self-govern. So, and the idea was that they would represent a kind of a bubble, a stable pool that had committed to these principles and were reliable interlocutors for each other and for foreign business as well. And the result has been that you now have this organization with over 800 members, about 200 of whom have committed to an annual audit of their anti-corruption compliance programs. And just recently, they've committed to delisting members who don't do something, who don't put in place some sort of program. So that's and then collectively they interact with the government for reforms that would benefit the business community in this regard. So that's an example of business taking upon itself, in the absence of government leadership, the degree to which these corrosive effects can affect profitability and taking action.
And just on the second question, I think the application is significant to local communities. We talk to U.S. businesses all the time, and they're really partnering with local businesses. They're in joint ventures with them. They're part of the business model. When they're getting social license to operate, they're working with all of the local communities, local businesses, training people, having symposiums, really engaging in that way. Now, does that usually lead to a result in helping their business model? Yes, but it absolutely has a positive effect, and generally that ends up being also a good hub for development, relationship building, skills building, capacity building, et cetera. And I think we're seeing positive fruits of that throughout the world.
Fantastic. And I can quickly answer both of those questions. So the first one on long-termism. So we have the UN-backed Principles for Responsible Investment, and they've been doing a lot of work around articulating the business case around taking a long-term view for businesses. You know, I'm going to be honest, it's a journey. You know, it is in terms of businesses really understanding and getting themselves out of this mindset of I need to deliver this for this profit plan year. But increasingly they're realising the power of acting responsibly and in a sustainable way, that it's not just a do-good, feel-good mentality, but it actually allows their business to be more sound and more sustainable in and of itself. So there's certainly a lot more discourse around this. I know McKinsey have written a lot around this as well. And I think that there is something to be said about there being an increased interest from investors. You know, not just your activist investors, but even just your general investors. BlackRock have also said that they are very interested in taking a long-term view, particularly around environmental, social and governance issues. So we are starting to see an increasing trend around that, which is incredibly encouraging. And also goes to the heart of the UN Global Compact and the definition of corporate sustainability. The second question, another great one, is around the obviously the application for local businesses. What's great about our organisation, she says humbly, is that we work with multinational corporations, but also small to medium enterprises. And to be also equally critical, one of the focuses that we'd like to turn to is being able to empower our small to medium enterprises. And by doing that was a great example, Frank, and also Malika, the examples that you provided, but is also empowering our local networks, really getting them to harness our multinational brands, so the Unilevers, the Nestle's, the Coca-Colas, their local offices, and encouraging them to engage more at the local level as well with their small to medium enterprises. We're also seeing companies also produce their own supply chain standards of conduct. And so we're seeing that not only in just policy statements, but also in contracts, that they too, the small to medium enterprises, or throughout the value chain, are consistent with the UN guiding principles, the UN, the OECD guidelines and other such normative frameworks. So I think that's an encouraging sign, but again, a long journey.
Yeah. So yeah, I mean, I think the fact that Larry Fink from BlackRock has been so outspoken about this, I think there is a potential sea change, I think, happening in terms of recognition that the sort of quarterly earnings model is not just bad for sort of environmental and social sustainability, but for long-term corporate sustainability. And so hopeful that will continue to, that conversation will continue to mature. And to the other question, I think one other thing just to add is, I think, we're starting to see a shift in approach where, local businesses are going to respond. There are local businesses that operate entirely locally, and I don't think that's what you're talking about. You're more referring to local businesses that form part of a value chain or supply chain that is global in nature. And both of those kinds of local businesses, I think, do need to be approached and do need to be educated about these expectations. Where we may have more leverage and opportunity is with those who are part of these global supply chains. And there, I think we're starting to see a shift away from what had been a kind of, on the part of the global companies at the end of those value chains who supply products directly to consumers, who had sort of been caught through exposés and other kind of embarrassing incidents with, basically being told you should have known that this was happening in supply chain, sort of saying, okay, well, we're going to put in place, these codes of conduct that everyone through our value chain has to comply with, and we're going to bring in auditors to sort of, do these flash audits and inspections and determine whether workplace safety or labor standards or other standards, environmental standards, are being met. And I think there's been some research to indicate that actually doesn't work very well, and I don't think it's entirely surprising that sort of strictly compliance focused approach isn't going to do the trick. What you may be starting to see with some companies is actually starting to invest in their value chain and sort of realize that we need more professional partners. And so building up the professionalism of the companies in their value chain, not necessarily in order to make sure that they're complying with the sort of minimum standard for X, Y, or Z social, labor, or environmental issue, but making sure that they have the capacity as a company to really understand all of the expectations that these professional, large global players have, including that they comply with all of those necessary legal and regulatory requirements. So I'm hopeful that there are companies like H&M and others that are trying to do that, build more sustainable relationships with suppliers, actually invest in their capacity in terms of management, et cetera, education and opportunities for employees throughout their supply chain, and hopefully that will start to bear some fruit and provide a model. Okay, we had two more questions here and here. I'll say on the same row. We'll take those.
Hamid's got one.
Olivier Kambala. My question still it's a bit of a follow-up on the LexisNexis question. I forgot the name of the lady. I guess, why is it still difficult to have a definition on the rule of law for the private sector with all this multitude of tools, the UN Compact, the OECD, and why is it still not possible to have very clear definition and set of guidelines and indicator for the rule of law for the private sector, just like for the rule of law before courts? You can measure in going to looking at access to justice, and there are elements of it, but why is it still complicated to have the same for the private sector?
Thank you.
I'm Justin Margolis, the International Association of Women Judges. I'm wondering, how would you evaluate the existing instruments in addressing the realities of marginalized communities within inside the countries, including women and girls, and indigenous peoples, especially with extractive industries?
Okay. All right, so those will be the last two questions because I think we're running up close to our timeline here. So anybody want to jump in on either of those? The issue of definition of rule of law. We started off by talking about the importance of definitions. There are, I think, different definitions. I think there is generally some consistency, but there probably are areas where we could tighten that up. What are some of the challenges on that issue?
Well, ever so succinctly, I think shameless plug is business for the rule of law. So we have established the business for the rule of law framework, and we consulted over 400, it was general counsel, also government representatives and also NGOs around the world across 19 countries, and they all engaged in a discussion around trying to demystify the rule of law. It's a very esoteric concept. Businesses, it's a concept that is sort of within the realm of lawyers, and it's like we've held it, in our embrace for quite some time, and now we need to let it fly. But I think what's important about that is that we're saying that actually this is owned by everybody. We have to demystify it. It's our responsibility to. And so part of that process was demystifying the definition of the rule of law for business and showing how business is already supporting the rule of law in so many ways. And we've actually collated about 185 examples of how businesses are already doing that across various industries, beyond philanthropy, and really about partnerships and also through their core business. So I'll stop there.
Very good. Either of you on that, or the question about how these instruments address the needs or the impacts on the sort of most marginalized, most vulnerable communities?
Well, very quickly on, so you were talking about extractive industries, and I think, so EITI comes to mind immediately. EITI, in recent years, it's not quite clear what the arc of its development is going to be. And EITI, for those who aren't familiar with it, requires signatory governments to reveal a certain amount of information regarding who's paying what for what natural resources, and a degree of transparency regarding beneficial ownership, which is helpful in pursuing what you're talking about. Regarding rule of law, I think fundamentally the argument there is that business flourishes when there's stability and predictability, and to ground that stability and predictability in commonly held principles makes a lot of sense. But also there's the corruption argument for stability and predictability, because you can buy that with bribes for a while anyway. So that's the fundamental tension often we encounter.
And I'll mention one other multi-stakeholder initiative called the Voluntary Principles on Security and Human Rights, which is specifically looking at human rights applicability of the actual voluntary principles in the extractive industry. And it's a way to really engage companies and governments and local stakeholders and international stakeholders to meet the actual human rights voluntary principles. And then the second shameless plug is that if there are marginalized communities that want to have a dialogue with a U.S. business about how it's operating on the ground in terms of corporate responsibility best practices, they can use the national contact points through the OECD to do exactly that. So it's a useful tool that is available to anyone in the world.
Yeah, I mean, I think on the second question, I think that there is a recognition of the importance of the sort of most vulnerable, most marginalized communities. The UN Guiding Principles on Business and Human Rights talk about identifying the most salient, most sort of significant risks and addressing those first. And clearly that includes identifying those communities that are going to be more likely to be impacted and less likely to be able to mitigate impacts of corporate activity on themselves or their activities. Clearly, there's more work to be done there, and I think there are a lot of great organizations, trying to work in that space. Since Malika mentioned the voluntary principles, something that my team deals with, I'll return the favor and talk about. The OECD also has developed a series of important guidances related to conflict minerals, so also applicable to the extractive industry, and really, all of this is sort of helping to spell out for companies. And map out how they can look into these sometimes complicated supply chains and sometimes very murky operating environments and understand the risks, not only to them, but the risks to others who are impacted by their activities. And by doing that, I think it helps all of us hold them to a higher standard, because it's no longer enough to just say, well, we've got to get the minerals from somewhere, and we just buy them on the market, and you know what? It's not up to us to solve those issues. That's the government of the Congo that has to deal with that. Well, what government of the Congo? How are they going to do that? And so I think there have been some very successful and important steps taken. Clearly, a lot of challenges remain, and we have our work cut out for us. So on that hopefully optimistic note, we'll, I think, end this first panel. Thank you to all of the panelists. Please join me in appreciating their time.